received this question: what happens to the common law wife if the common law husband dies? Well, let me set the record straight. In Washington state, we don't recognize common law marriages, but we do recognize what is called a committed intimate relationship, previously known as a meretricious relationship. What does that mean? It means that two people hold themselves out as a married couple. They maybe introduce their spouse as, here's my husband, this is my wife. They live together, they share joint bank accounts. They basically present themselves to the world as being married, even though they're not legally married. In the state of Washington, if that is the case, then actually each of these partners does acquire rights as if they are married. Not the same rights as a married couple, but as if they are married. Equitable rights to ownership, for example. So it complicates any probate situation. Certainly when one of the couple dies and they're not married. The court will take a look at, are they considered a committed intimate relationship? Assuming that the answer is yes, then the court is going to look at all the assets and is going to divide the assets. And this can happen irrespective of whether there is a will. So for example, let's say the husband-ish in the relationship owned 6 rental properties, and the wife had none in her name, but together, and when I say wife, you know I'm talking about not legally married, but they were together 30 years, and they, everything they did during these 30 years was as if they were a couple. And the male in this situation said, oh, all these properties go to my children, none go to the person who is the, quote, common law wife. The court won't allow that. The court will recognize that that wife has a equitable, like a community property interest in those properties, and likely will award half of that property to the surviving person in this committed intimate relationship. So beware if you think that, oh, I don't have to provide for this person because we're not really married. The law is more complicated than that. The best thing to do is to get some sort of property agreement where you spell out what your property rights are, have a will that spells out who gets what, talk to an attorney who will say and will bring to your attention, you may have to provide for this person, especially if you don't have a property status agreement, because the law requires you to do so. Without things spelled out clearly, what will happen on a death likely is there will be litigation. And one of the reasons probate gets a bad name is because this is a messy probate litigation, likely where one family is saying, we get everything, the surviving person says, no, you don't, and it's going to result in time in court, legal fees. So what I want you to be aware of is you can address all of these things, deal with them in advance by seeing a good estate planning and elder law attorney.